Welcome to the Future of Resolution, Miles Mediation and Arbitration's podcast. I'm one of your hosts, Marcy Dixon. On today's episode, we're going to switch it up a bit and have senior neutral Joe Murphy speak with Buck Rogers of Freed Rogers Goldberg here in Atlanta.
All right, Brian D. Buck Rogers, I want to thank you for joining us here today. You've been a friend and a colleague for many years now, and when there was discussion of having a podcast with a mover and shaker that I was interested in learning more about, your name rose to the very top of the list. And I'd like to pose some questions to you today, some general, some specific, some about you personally, some about your philosophy in the law, philosophy in life. And I may even ask you to predict the future of what's next by the end of this, for fair warning.
That's fine. I look forward to it.
All right. My first question is, who is Buck Rogers? Your dad was and is a legendary trial lawyer, not only in the state of Georgia, but widely considered one of the best lawyers in America. My dad was an aluminum and glass salesman. If I'd gone into that business, I would have had a lot of pressure because he was an award-winning one of those. But I took another turn in my life. So for someone who's followed in his dad's footsteps in terms of the profession, growing up in that environment, tell me a little about your dad and the early influences that shape you today.
Well, I guess, first of all, I was not aware of his legendariness as a young person, but, I do recall as a boy realizing how much he worked, and to that point, maybe how little he was at home. He worked probably every Saturday and a half Sunday, pretty much every other weekend. Then later in life, when I started, being more aware, people would make comments and things of that nature. We didn't have a great deal in common because he was so much of a lawyer until I became a lawyer. And then our conversations were very free-flowing. But I would say that as a young lawyer, well, first of all, before I went to law school, he discouraged me from going. He just said, the likelihood of success is, you've got all these really bright applicants, and then you get 1,000 applicants and 200 accepted. And of those, 20 will be in the top 10%. And of those, 8 will get the job of their choice. And of those, 1 will make partner in the city they want to live in, and so forth. So he discouraged me from becoming a lawyer. But once I became one, we had a lot more opportunity to share thoughts. As for following in his footsteps, those are some big shoes to fill. But my practice is so remarkably different that I'm not really in the same path. It's the same degree and same profession, but not the same path. And I'll tell you, one of the things that's been great, as a child, I grew up around people like Emmett Bonder and Miles Alexander, who are my dad's friends. And so this is sort of the group of people that co-parented my parents with me as a young boy. So I was surrounded not just by my father's influence, but his friends' influence. As a young lawyer, and to this day, I'll call on him for advice and give him a situation. And what I frame it in, I've got a riddle for you. And it's a very complicated fact pattern. And, I've got some examples I could share with you if you're interested, but, he will say something like, how many lawyers do we have working on this and how much time? And I'll say, it's you and me, and I've got 4 hours till the hearing. And then he'll call with the answer. So I've got one of the most overqualified, undercompensated associates at my disposal, which has been very nice. And I'll tell you another thing that's been interesting is as my career has developed and taken its shape, his perspective on what I do and why I do it has changed. He started off, he cut his teeth as a State Farm defense lawyer, and then later got into antitrust. But he is much more, I would say, compassionate towards plaintiffs' claims now than he was 25 years ago. So I think he's kind of left his defense-oriented days and he's kind of a little bit more plaintiff-oriented now.
Sounds like he's maybe taking after you a little bit, perhaps.
Well,
I know he's got to be very proud of you. there's only 100 top 100 lawyers in Georgia, and you and your dad comprise 2% of them. So you, I know you're both probably very proud of each other. You mentioned being a defense lawyer, and I know that's how you started the practice on the defense side. Obviously, you've made quite a name on the other side. So how did being a defense lawyer instruct, inform, influence the way that you practice plaintiff's law?
That's an interesting point. I was very lucky or blessed to have the opportunity to have Bob Corey as a mentor. And I don't know if in law firms they are doing appropriate mentorship anymore, or if it's just go out there and do your best and I'll criticize you later when you don't do it well. But Bob took an incredible amount of time to try to teach me how to practice law. And I'm very grateful for that. He kept a timesheet, as you might remember those days, in a folding folder, sort of like what you have in front of you. And when I came in and talked to him, the first question, he'd leave the folder open. And if I asked the next question, sort of the why behind how, he would close it, put it aside, and talk to me as long as the conversation needed to be had. And then as I got up and left, he'd open it back up and go back on the clock, so to speak. I bet his productivity dropped 50% the first 2 or 3 years of my being his associate because I took so much time. He also brought me along as second chair on many, many, many opportunities that a young associate wouldn't otherwise have. I didn't bill for those because being second chair at a plaintiff's expert deposition doesn't add any value. But he let me experience those, and it came a time when, somebody had to take a plaintiff's expert deposition, and there weren't any partners that were available to do it, and some of the associates had not done it before, but I'd sat second chair enough times that I did it. So to your point of how did it influence being a plaintiff's lawyer, one, it's taught me the value of mentorship, so I try to teach others. But two, it taught me that if you can take the opportunity to learn, even if you don't get direct value from it, i.e. billing or, in the plaintiff's world, a fee, but you're learning and improving, that is a value to you. And then finally, with just the defense work, you can't, being a young lawyer, it's hard to develop your own clients. They're sort of institutional clients. And so the change from defense work to plaintiff's work was really one of practicality. As a young lawyer, I can't get a new client in the defense world. But as a young plaintiff's lawyer, frankly, a plaintiff doesn't know the difference between somebody with 5 years experience or 15 or 50.
Now, when you and I first met, it was a case that brought us together. At that time, I was a defense lawyer, and this was a very serious case. There was a two pedestrian incident. One was a fatality, one was a very, very serious injury. The case was remarkable for two reasons. One was the damages were very profound, but the other one was because the liability at the time that you took the case was very weak. In fact, my client assessed it as a zero liability case with no offers intended to be made for either plaintiff. And I had a front row seat as you, and then later when you joined Michael, I worked on these claims, remarkably taking a case that I think, as I recall, had been passed by other lawyers for just not viable, and achieved two very high dollar settlements, convincing even an insurance company that had already decided these cases had no value, that they were cases of great value. And I have two questions, really. The first one is, what advice would you give lawyers selecting cases, particularly on the plaintiff side, where you have to go out and drum up and screen cases? What advice would you give them on problematic cases and which problems can be lawyered away or improved with lawyering and which ones can't? And secondly, once you take a case like that, how do you approach a problematic case?
Well, so it's a contradiction in logic that the best lawyers get the easiest cases or the best cases. And you hear about these clear liability, great coverage, horrible damages going to a great lawyer, and you're thinking, what a waste. They don't need that lawyer. And the other part of that contrapositive kind of is that a young, less experienced, less, accomplished lawyer sort of takes what they can get and makes the best of it. But you have to be smart. Colleagues of mine will say that no business is better than bad business. But to my point a moment ago about opportunities to learn, my thought was working hard would still improve a skill set. Now, you got to be balanced with that and don't waste too much time on hard cases. But to give you an example, I lost a trial about a month and a half ago in DeKalb that, in hindsight, I didn't really take the case as you traditionally do. I was brought in by a referring attorney who later had some difficulties and was no longer in the case. The defense attorney who originally had the case had some health issues, and the one that ended up trying it was not the original one. So the case was 11 years old, and the lawyers trying it were doing the best they could. But at the end of the day, it appeared that my guy ran a stop sign. And no amount of lawyering is going to change that, what probably turns out to be an indisputable fact. Even though there's no real witness to it, it is a conclusion that the jury had no choice but to leave with. The
tough question is the case that you and I, on the one that you produced a remarkable result from what looked to be long odds at the beginning. Would you take that case today?
I would. I gravitate towards challenging, difficult liability cases. And I will tell you that in hindsight, what I figured out is I'm good with difficult liability cases, and Michael Goldberg is really good with complex medical cases. And when we worked together, he would handle the medicine, I'd handle the liability. And he would try to explain the medicine to me, and I would just interrupt him and say, is there any reason why both of us need to understand this? And he says no. And I'm like, okay, well, I'll go do what I do. But I would take that case, and I actually like those cases because they're interesting to me. What was difficult and challenging about that case...
Well, I like that case a lot until you and Michael started working on it. I started liking it less and less.
Well, so what was difficult about that case, among other things, is, the pedestrian that was killed obviously can't tell us anything. And the one who was badly injured, he's got his versions of what was happening and what he was doing. And then the defendant had his versions. And as you will remember, there were 2 or 3 different possible scenarios based on what I would say 4 different possible factors that affect those scenarios. And what I ended up doing was doing a reenactment or a reconstruction based on the 3 or 4 different speeds and 3 or 4 different movements of the pedestrians that might have happened. And what that was intended to show was, be illustrative of no matter how these facts come in, it's likely to look adverse for the defendant. And the case really kind of hinged on the deceased pedestrian had a butterfly fracture to her right femur. And that was conclusive in demonstrating that she was faced in one direction and not the other. And the defense had been, based on the driver's testimony, kind of a dart out, walking out, but she was facing the opposite direction. So either she's walking backwards or she was stationary. So having the perseverance to get a biomechanical engineer to look at every x-ray and find that butterfly fracture, that was kind of a key turning point in it. And I'll also say that we had, at the time, a skirt trooper who was with the defendants on the conclusions of this case. And he and I had some very difficult discussions about what he thought happened and what I thought happened. And, I'm happy to say he's one of my best friends now, and I'm getting ready to go to New York with him for a reconstruction seminar for 3 days.
Yeah, my recollection of that deposition was you flipped him like a pancake.
Well, yeah, and that's not really fair. I had
No. You made him think about some things that in our prep we had not thought about, and you got some good stuff out of him.
Yeah, and I think it was difficult for him to admit that he was wrong. And he's now in private practice, and I work with him a good bit as a reconstructionist. And what sets him apart from other reconstruction experts is that he is willing to admit that he's wrong and willing to consider facts that he didn't know. And you can appreciate as a defense lawyer, if you can prove a fact and the reconstructionist will not even accept it as fact, you might have just won your case. So he at least is willing to consider it.
In getting ready for this podcast, I had typed up some questions and topics that I was going to cover, but I've had to wedge in something that has occurred since then. Mid-September of this year, you achieved a not 7, not 8, but 9-figure verdict in the case, which in itself is remarkable. It also happened in Fannin County, which in the business we would say is a conservative jurisdiction. So is there anything you can tell us about that case and about that verdict here today?
Sure. That it was an incredible fact pattern, and the clients are what drove the value, not the lawyering. Fannin is incredibly conservative, but it appealed to their law and order conservatism because the defendant had been inhaling duster to get high. And so you had the law and order dynamic, and you had horrific damages, and then a great group family of clients. So that's what drove the value.
This was a family from Florida vacationing up in North Georgia.
That's right. A family of 6 vacationing with some relatives who'd rented a cabin. They're trying to get out of the heat, 4th of July weekend. And they had attended, they took the train from Blue Ridge up into Tennessee to attend the fireworks. The same fireworks where the defendant, a 16-year-old boy, was huffing. And then they were on their way home from the fireworks and had stopped at a convenience store to get diapers for their 3-year-old who was potty training, and stopped at a red light, and they were struck from behind at about 80 miles an hour. The defendant driver never touched his brakes because he was just incoherent. And there were other dynamics of that wreck that, if you hear the fact pattern, you're like, wow, it almost sounds like a law school exam made up facts. But prior to the collision, the defendant driver, who had a companion in the car with him, did like 80 yards of guardrail scrape. So there are witnesses talking about sparks flying. They then blew through a red light, and at the red light was a county deputy waiting to get the green signal. It just changed. He starts to pull forward, hears the sound of the guardrail scrape and the car riding in the gravel and the gore, stops. The defendant flies by him. He pulls in behind him. When the collision occurs, he puts on his blues, and that preserves the dash cam. So all of these facts and factors and dynamics are interesting, but when you actually have it on video and your first witness is the deputy that plays the video, you're like, wow, you can't do anything about that. So the family was great. And, to be fair to the defendants or their counsel, the insurance company had offered limits time and time again. If they could have gotten out of this case, they would have. But because of several factors that were sort of outside the control of any of the lawyers, we were on a track and we were going to try this case. And among those is, we had resolved some ancillary matters with other defendants, maybe 6 weeks before, and then again 2 weeks before, and one, technically got dismissed the night before. And that defense attorney ended up entering an appearance on behalf of the remaining defendant. So leading up to trial, the whole 6 weeks of prep, we're also removing other claims. And so at the end of the day, the family just wanted to have a trial. They wanted to have their day in court. They wanted to tell their story. The defendant in the criminal matter had pled out, and so there wasn't a criminal trial. And so this was the family's opportunity to tell their story, and so they told it.
And obviously, the jury responded and got it. Speaking of, you just mentioned 6 weeks of prep time leading up to a huge case, and that segues nicely into the next question I wanted to ask you. You are a remarkable example of someone who balances work life, family life, a lot of public service. Most recently, you're the immediate past president of the Georgia Bar Association. Just learned today you're on the advisory board of the Shepherd Spinal Center. List goes on between work responsibilities. I know family is very important to you, and then you've got all of this other stuff that you do. How do you balance all of that, particularly when you've got situations where you may have to immerse yourself in weeks of trial preparation to be who you need to be for that person? What's the secret to that success?
Well, it's not anything that I do deliberately that is successful, but it is the dynamic of all of those other commitments that naturally pull from one another that creates inexplicably a balance. So if you have a trial and that takes 100% of your effort and time, you are naturally going to neglect family commitments and personal commitments and things of that nature during that period. So then once you get done with it, you kind of have to take a deep breath and say, all right, let me reconnect with some friends. Let me reconnect with, kids and that sort of thing. Other board activities will demand time that pulls you away from work or family. And then family obligation pulls you away from board activities and other things. So what you end up is inadvertently striking a balance. And that's only possible by virtue of the fact that I'm on these boards and serve in these capacities. And, as I've explained to my law partners, about 50% of my, what we consider work time is spent doing something other than my practice of law. For example, the state bar took up about 50% of my work time. And so board activities suffered and things of that nature suffered. So now that I'm immediate past president, I have the opportunity to attend to those things a little bit more. But the problem lawyers have, I'm in a fortunate situation because I have other commitments that pull away from work. The problem lawyers typically have with work-life balance is, as a profession, we tend to discourage anything other than the practice of law. Your partners expect all of your efforts to be dedicated to the practice of law. If you're an associate, the partner you work for absolutely expects all of your time to be spent doing the practice of law. And it's not like they come in at 4 o'clock and say, hey, why don't you go take a long walk and get your head right? Or, knock off early and go take your wife to dinner, something like that. So as a profession, I think we need to be mindful of what we do to ourselves and each other that discourages work-life balance. And you really have to be conscious of it and aware to make a change and create a balance.
I want to dig a little deeper on that topic because, over the past few years, I know the Georgia Bar has increased its focus on the mental and emotional well-being of its membership, and that trend continued under your leadership. And we both know lawyers, sadly, who have taken their own lives. As lawyers, what are signs of possible depression, suicide, or addiction that we should be looking for in our associates, our partners, our colleagues? As a mediator, I probably meet and see on a daily basis more lawyers total than a lot of lawyers do, because I'm always dealing with other lawyers every day. It's a different group, and I'm always surprised when I hear that something has happened with someone that I would have never suspected it. So what insights do you have that you could share with us on that?
Well, okay, so there's a couple of things on that. I think specifically with suicide prevention, on the State Bar website, it has the 800 number where if you or someone you know you think is at risk, you can call. And there are people available to talk to you. Also on that website is 12 signs of sort of the elements that lead up to a suicide situation. And not to be facetious, because it's not a funny topic, but if you look at those 12 signs, you would see in it 4, 5, 6, 8, 10 of these signs that you can attribute to yourself, to me, to people you know and care about. And it is things like irritability, rage, depression, withdrawal from friends, not being able to sleep well, alcohol and drug abuse. And these are things that, because they are so prevalent and common in our profession anyway, it's hard to see where the trouble is and where it's just normal practice of law. And so you do need to be mindful of it. And when you look closer at the list, I think maybe you draw a distinction between somebody who is irritable because a mediation didn't go well. But if they're irritable again the next day and the next day and the next day, then there might be a problem. And, not eating well, not sleeping well, not taking care of hygiene, things of that nature. But I think it's worthwhile to look at the website, and it's under the wellness program, suicide prevention. Just click on it. Obviously, it's anonymous. It's got the 12 signs listed. You can think about your own life, what you do, how people perceive you, and what you perceive in other people. And the second thing to do is also in that same drop down is the lawyer assistance program. And your bar dues provide for you 6 free sessions with a professional mental health professional that's there to help you work through, talk through, and help. And this is completely anonymous. It is totally separate from the State Bar. I mean, we pay for it, but the State Bar never knows anything about it. And it's completely separate from, say, the Office of General Counsel, which does disciplinary. So if you were to call a lawyer assistance program and tell them that you're drinking in excess because you've mismanaged your escrow account and you're afraid the bar's going to find out and you've been robbing Peter to pay Paul and you can't get on top of it, Office of General Counsel doesn't find out about that. They start dealing with what you're doing to try to cope with that problem. And along the way, they're probably going to recommend that you get an accountant to try to straighten this situation out and fix it before it becomes a problem where a client's adversely affected. So there are things you can do. And, the other part of it is, looking at the signs and looking around at the people you are running into. And just let them know that you care. Because a lot of these lawyers are convinced that it's just them against the world. And part of the problem, particularly in what we do as tort lawyers, there is a person and his job is to defeat me. And my job is to defeat them. This is not a win-win. In alternative dispute resolution, we can talk about win-win. But at trial, there's a winner and there's a loser. And lawyers take very personally their losses. And that's understandable. But they carry that burden with them, and they carry it out of the courtroom and they carry it back into their homes, and it is a cloud over them for who knows how long, maybe forever. And so, the longer you've been doing it, you end up with some battle scars, and it's easy to see kind of the toll it takes on what we do. If it's a win-win, it's easy to have a smile on your face when you're walking out. And frankly, getting to the mediation point, I'm sure you've heard the saying or said it yourself, a successful mediation is really a lose-lose. Both sides are unhappy with the resolution. So even a successful mediation doesn't make you particularly happy.
No, that's an excellent segue, by the way, to the topic of dispute resolution. And I have to say, in following up what you just said, I mean, when I was practicing law, it was not only the other side that was out to get me. It seemed like the courts were out to get me. It seemed like my law partners weren't necessarily out to get me, but as you mentioned earlier, we can have divergent interests, and there's all of the struggle that goes on with that. And then there's your clients, who each one is your special client, and they don't understand the other demands on your time. So all of that does come together, and I think you've summed that up nicely.
Let me address one thing about that, and I think it's a really good point. When Robin Fraser Clark initiated the suicide prevention program, as state bar president, one of the things she did, and I'm not saying it, there were other people that were interested in it, but she kind of spearheaded a lot of what the state bar has done. One of the things she did is she took the Judicial Council to task on this. And the Judicial Council has representative members from every court in the state. And she basically said to them, go back to your constituency, go back to your members, and think about how abusive they may be to litigants. And it's not like lawyers don't need to be admonished sometimes. We get it. But sometimes they don't need to be admonished, and maybe not in front of their clients, and maybe not in the way that's happening. So she did talk to that group. Now, how lawyers behave to each other, professionalism and civility, is something that is not only an ongoing problem, but it is an increasing problem. And I frankly think one of the problems is the send button. So if you could take send off your phone and enter or return off your computer and still have some function, great. But the passive-aggressive nature of emails is problematic. How we treat each other. My experience in handling matters all over the state is that in smaller legal communities, people are more accountable to one another and they behave better. In larger communities like Atlanta, they tend to think they're going to get away with it. Now, even in Atlanta, there's a handful of plaintiffs' lawyers, you can name them on one hand, who you expect to see in here on the types of cases. And there's about 10 defense lawyers. And that's a pretty small community. And so we do see each other time and time again. And so I'm sure you've experienced in your mediation, you're seeing a lot of the same plaintiffs' lawyers, a lot of the same defense lawyers, and they see each other. So they get along really well. They're going to fight like hell during that mediation, but afterwards, they're going to be kind of friends, or at least professional colleagues.
Our conversation will continue in the next episode. I'm Marcy Dixon. You've been listening to The Future of Resolution, the podcast. You can follow The Future of Resolution on Miles Mediation and Arbitration's Instagram, Twitter, and Facebook. If you haven't yet, go to Apple Podcast or Spotify and subscribe, rate, and review this podcast. Join us soon for another interesting discussion. Thank you for listening.